Alright, so about 4 weeks ago, the judge called me and my lawyer into court without letting anyone know that we had a court date that day, so there was nobody in the gallery and nobody knew what was going on. But she addressed a motion that my former lawyer had written concerning Facebook, concerning the warrant that was issued and how it was approached, how it was violated, so on and so forth. The actual motion is called McGuire's second motion to dismiss or suppress evidence being Facebook and the proofs derived thereof. The first thing that the prosecution was asked was whether or not they violated the search warrant. In the search warrant, there's a clause that tells them that they have to do away with the information that they don't use, has to be destroyed. And they blatantly said we put it all in the discovery. All the Facebook we didn't use, 13,000 pages from me alone. I know 80,000 from another guy. Add that up to all the defendants on Facebook. That's a lot of discovery. So, any guess why we have a complex case? Anyways, apparently the same thing happened in Oregon. One of the lawyers filed and they said, hey, you know, these guys have kept the evidence they're supposed to throw away, that they seized, then searched, and kept it. And they said, well, we're sorry, Your Honor, it was a mistake. The judge gave them a tongue lashing, and that was the end of it. So here we are again. We have prosecution admitting that it was a mistake, that they did it on purpose, but they said it was for my benefit. So just in case there's anything in the Facebook that I needed that had nothing to do with the case that might help me with the case, if that makes any sense, you got me. So we're dealing with a lot of issues here. Quite a few things that I can't go into detail because the hearing is tomorrow. But basically, if the prosecution gets away with this, then they have violated laws. They violated their own search warrant. They violated a search warrant. They violated how many days they had to go through the evidence. They even wrote their own reports on when they did it, how they did it, and the dates on everything. There's nothing here that I'm making up. We've got 200 pages that they said they were using of mine, and the judge asked me if I knew where those 200 pages were, and I told her I did, as long as they weren't holding anything back. Those 200 pages have nothing to do with my case, as you can imagine. It was a general warrant in the first place, and as you know,
it's from an inmate facility.
It's already a violation of the Fourth Amendment. The items taken are First Amendment protected items. So look at that. So we have an illegal search of a Facebook account. They have no probable cause for anything that they seized. Facebook can chop things up, and Facebook can give you exactly what you asked for. Everything is labeled. There's no hunting tech. There's no digging for stuff. Everything's there. So they listed everything that they wanted from Facebook with no probable cause for any of it. And still got everything. There are multiple lies told in the search warrant, in the application for the warrant. It was an overbroad warrant with no probable cause, which is not just a direct violation of the first, but the fourth as well. And we don't even have to bring the Constitution into it just to show how they violated their own search warrant and the procedures for the quarter time limit to the non-responsive material that wasn't destroyed. They also searched my Facebook before getting the warrant. Well, one could make the argument that if you're standing in your house with your blinds open in front of the window, someone in the street can see you. It's the same as like a Facebook. You know, they look at your Facebook and they can see you. The problem here is they got an application for a warrant because they couldn't see what was in my Facebook. They said I might be hiding things, or I was hiding things that would connect me to domestic terrorism, and they would find it only by going through my Facebook. So they say that they could see in my living room window, and there I was standing. But I walked out of the room, and now they want to know what's in the other rooms, because I might be hiding something in there, even though they didn't see that I was hiding anything in the living room. So they get a warrant just based on that. Blows my mind. So I have multiple things here.
From an inmate facility.
I have 8 categories. Each category has a list of things I violated. But it comes down to the conclusion is this: the warrant timeline was exceeded. No factual probable cause exists to seize all items listed on the Facebook content in its entirety. The warrant was general, overbroad, and vague with no particularity. In furtherance, Section 3 of the warrant was violated. No non-responsive material was seized, not destroyed, and returned. It was not destroyed, not returned, and not sealed. The agents were indeed fishing, and Facebook was searched before the warrant was issued. Multiple lies were told from an application from the warrant to the initial detention hearing. Since the Facebook post is protected by free speech and the First Amendment was violated as well as the Fourth, all in an attempt to rummage through personal items, looking for any evidence to further create a conspiracy. If you use Facebook, you got to realize that you have friends on your Facebook who have identity numbers to their own Facebook. And so when the government seizes one person, and they can come up with a good enough excuse to seize everything from that person, they also get everything they need to locate anyone connected to them. So this was all an attempt to build a conspiracy. And I've gone over and over about how this is all building a conspiracy. We know there wasn't one. They had to make one up. That in itself is the conspiracy. That's the crime. My lawyer tells me we probably won't see these prosecutors taken out in handcuffs for their crimes, but it's a pretty good way of winning the motion. So if you can remember, Todd Engel was convicted on Facebook stuff. The Facebook stuff is going to be heavy in what they're going to try to use to create a conspiracy that didn't exist, sharing people's videos that you didn't know. So the best thing that we need to do is protect our First Amendment right to make a Facebook post in the first place. And if this goes out the window, I really don't know what to tell you. I really don't have much hope for the justice system in the first place. But this Judge Peggy Lean tomorrow, she's the last one who can stand up and correct this. And I really hope that she does. So I appreciate you listening to me. That's all I got for the Facebook. Thanks, guys.